Let's talk about objections to the form of a question or to an answer. So the most common objections would be assuming facts not in evidence, being non-responsive, asking a question that calls for a narrative, being argumentative, asking compound questions, leading questions, or the old asked and answered. So when we are thinking about objections to the form of a question or to an answer, those are the primary objections to be made. But what do they look like? So assuming facts not in evidence, what you would typically see, and I can give you an example, a prosecutor stands up and says, "Now, officer, we know from studies that the HGN is 88% accurate. Did the defendant have HGN?" Well, that would be assuming facts not into evidence if no one had testified that there were studies on HGN and that the percentages were 88%. So that would be assuming facts not into evidence. And assuming facts not into evidence is also called testifying. So, Your Honor, counsel's testifying. What would it look like coming from a defense attorney? Well, if the defense attorney says, when my client was driving down the road, fell asleep, swerved, you stopped him, right? Well, if there had been no testimony or evidence that the defendant had fallen asleep, then counsel's testifying or assuming facts not into evidence, and that's certainly objectionable. Because we don't want facts or evidence coming from the attorneys. We want it coming from the witnesses. Attorneys are there just to draw it out of them. So what about being non-responsive? Well, a good example of being non-responsive would be, let's say a defendant's testifying, which they have a right to do, but sometimes it's kind of dumb. If the prosecutor says, "Mr. Smith, did you have something to drink that night?" And he said, "Yeah, I did." "And what was it?" "Coke." "Anything in that Coke?" "Yep." "What was it?" "Ice." "You know what I'm talking about, Mr. Smith. Anything else in there?" "Yep." "A straw." "Were there any alcoholic beverages in there?" I wouldn't say alcohol beverages were in there. I guess it depends on what you're calling an alcoholic beverage. "Was there any alcohol in there?" "No rubbing alcohol." If a witness clearly should know what you're asking, and they're given the politician's answer where they're dancing around it, that is being non-responsive. And you would look at the judge and say, "Your Honor, the witness is being non-responsive. I would like to have you instruct them to answer the question." So that is one of the objections that can be made to a witness. What about a question that calls for a narrative? When a question calls for a narrative, it would be something as simple as, "Without leaving anything out, tell us what happened that night." That is so broad. Now, here's the thing. If you're on the other side, you may not want to object because that long narrative is going to put people to sleep. We shouldn't ask questions that call for a long narrative because it's not very judicially efficient. And it's not the best way of highlighting the facts of our case. So stay away from that, and it is objectionable. What about being argumentative? Well, that's pretty self-explanatory. But you got to be careful. Just because somebody's asking the hard questions on cross-examination does not mean they're being argumentative. Being argumentative is when you are trying to embarrass the witness or you're picking a fight just for the sake of picking a fight. And it'll become apparent when it happens. What about compound questions? If you say "and" more than twice, you're asking a compound question. "Officer, you saw my client driving, and then you saw him cross the center line, and then you arrested him for being drunk." Well, if you keep saying "and," then you are asking a compound question because you are asking them to respond to multiple facts in that one question. Keep your questions short and to the point, and not only will it not be compounding, which would be confusing, but it also is the most efficient way to highlight those facts. What about leading questions? Well, this is one that stumps a lot of people because you can ask leading questions to kind of develop testimony. your name's John Smith and you work for Little Rock Police Department. You were working on January the 12th, right? That is not necessarily suggesting an answer. It's not anything that's in dispute, and it's going to make sure that we can get to the good part. Because in a trial, you want to get to the good part. So leading questions are questions that suggest an answer on pertinent facts. So you really have to decide where you're going to object and where you're not. And a lot of times you will hear, if it calls for a yes or no, then it's a leading question. And that is not always so. It is only when you are suggesting an answer. So, just asking a question that's yes or no is not leading. What about asked and answered? Asked and answered is something that you will get objections to, where you are cross-examining someone and they're being non-responsive and they keep dancing all the way around it. So, sir, did you have anything to drink? Yes. What was it? Coke. Anything in that Coke? Yep. What? Ice. Anything else in there? Asked and answered, Your Honor. No. It was asked, but it was not answered. So, asked and answered is when someone has been asked the same question over and over and over, and they have given an answer. Now, sometimes it's not the answer that somebody wants, but it's the answer. But if it's a non-responsive answer, the question's going to get asked over and over again, and it should. Now, if you are in a trial, just because there's an objection, do not go, oh my God, they objected, I'll rephrase the question. Because you may not be wrong. If you're right, stand up for it, tell the judge why you're right. If you're wrong, rephrase or withdraw the question. That is the simple steps of objecting to a form of question or objecting to an answer. Hope it was helpful.